Thank you very much, Rita, for that detailed report. We now cross over to James Smart, who's standing by at the Supreme Court to give us a breakdown of this case. James, over to you.
All right, indeed. Thank you very much, Betty. I'm just outside the Supreme Court where that titanic battle just took place a few hours ago and just taken rest and about to continue tomorrow. And I'm joined by Ambrose, with the LSK council member and advocate. Ambrose, this is supposed to be a date for setting rules, case management, but as it appeared to us and 40 million Kenyans, it was an all-out war.
Yes, today was a day of setting down the ground rules. Now, as you set down those ground rules, each party tries to get an edge, because it is on the basis of those ground rules that the argument will be put in place. For instance, if you are told you'll take 30 minutes in arguments, when you feel you want 2 hours, this is the time to protest and say, look, I don't want this, I don't want that. Again, this is the time when all other issues are sorted out, so that on the third day, it will be pure arguments, hearing the case within the 2 days.
All right, and speaking of it, the first thing that we had today was that curious case of the amicus curiae, if you like, the Attorney General and the Law Society of Kenya, which you're a member to, were applying to be friends of the court. The Attorney General was allowed, the LSK was not allowed. But first, Kenya is asking, why would the LSK and AG want to be the friends of the court anyway?
Now, let me explain to you what an amicus curiae is. It's a friend of the court. Now, our court system is called adversarial, meaning the judge does not enter into the arena. The two sides, the two protagonists, they put their cases and the judge decides. Now, when putting their cases, each side wants to win. Do you understand? And that means that a party will not give that evidence or that material that would actually injure his or her own case. Now, in those circumstances, the court can have some resource people who are friends. A friend of the court who will put any material, because he's not interested in the outcome, but is interested in assisting the court to reach a just and fair decision. So that is how the Attorney General can come in as a friend of the court. That is how the Law Society, while discharging its mandate under Section 4 of the LSK Act, would come as a friend of the court. Unfortunately, this time round, one of the LSK officials had sworn an affidavit in support of the court petition. Now, I think that the other side, the other people took into account, and therefore they said, in the circumstances of this case, therefore, LSK would not be taken to be a friend of the court. It looked like it had taken sides, but it was not the entire LSK. It was just that one of them has entered the arena. And in deciding whether there is bias, even an appearance of bias is bad enough. That is why, for the first time, we lost it, and it's very painful to us who are in the Law Society.
All right, that will say what happens to that. But get to the next issue that had to be dealt with today, the issue of collapsing all the petitions into one case. That's another thing that took place today. And again, just wondering, we have hundreds, and many parties interested in this. In either petitioning it or responding to it. Why was it important to have it as one case?
Now, there were 3 other petitions apart from the petition by the Prime Minister Raila Odinga. Now, the petition by the Prime Minister is actually the central petition, the main thing. But alongside that petition, ancillary to that petition, there were other issues that arose, and people filed petitions that relate to the election. For instance, there's a petition that seeks to an interpretation of the court to decide whether spoiled votes are actually supposed to be counted or excluded. So in order to decide all these together, because one has a bearing on the other, it was in the interest of management of time, management of justice, in the interest of justice, to ensure that they are all put together. But if you look at it, the core case is that one by the Prime Minister.
And then the final thing that happened today that was extremely important was the affidavit that was attached, the 900-page affidavit that was attached by Oraro, saying it's a response to the response that was given by the respondents in
Yes.
the original petition, that is this petition.
Yes.
And it was a huge thing that
Yes,
up to now has to be decided, and where we are right now. Explain to me how that affidavits work, and what are the judges be looking at in making that decision tomorrow.
Now, in filing the presidential petition, there is constraint of time. There's a time limit. Within 7 days, you have to file your petition together with supporting documents. The other side has to be served, and they have to file theirs within a set time. Now, within that set time, each party is supposed to bring all the necessary documents. What apparently the court team did was that they looked at the documents that the others had filed, the other side had filed, and I think alongside they discovered that there are other new material that they needed to bring before the court. So they prepared and filed an affidavit. Now that affidavit, the other side, the respondents were of the view that he needed, first of all, authority from the court. Secondly, it is like he's bringing a new case, and therefore they were asking the court to expand it, to strike it out so that the hearing proceeds. The gist of the argument was that would require that they also given time to respond to it, and that would go beyond the time that the Constitution gives.
But the arguments we had today,
yes.
Just very quickly, from the Jubilee Coalition saying, listen, this is a new evidence, it's mutating the case
yes.
and changing the nature of the petition.
Yes.
But Oraro's argument
yes.
was such that says that you responded to what I said earlier,
yes.
and part of what you said
yes.
is I'm just attaching and annexing it.
Yes.
You're saying that the elections, for instance,
yes.
the electronic system failed because of system ABC. I'm just attaching that
yes.
as part of what you said.
Yes.
So that is the conversation that you're going to have now.
Yes.
So what's the court looking at?
Now, as at now, the court is going to look at whether the act of filing that affidavit was proper. Then the court is also going to look at the content. Does it mutate the case into something else, the petition to something else, or it adds flesh to the original petition filed by the court? If the court is of the view that it has mutated the case, it is bringing a new dimension to the case, the court can decide to expand it. If the court is of the view that it is only adding meat to the original petition, then the court would actually allow it. The court will also have to look at whether filing it without authority is wrong, and therefore they should strike it out. Now, looking at the intensity and the importance of this case, I don't see the court being very technical. I see the court trying to look at the substantive justice, and that means that procedural mistakes that a party may have done may actually be overlooked for the sake of the country, for the sake of the 40 million Kenyans. Because you'll find if, for instance, you strike out that affidavit, the Prime Minister will say, that is where my petition was rotating. The one you have excluded, that is where I would have won the petition. So maybe to avoid all those things, the court may decide, let us look at the substance, let us look at the overall value of the petition and the response, and then make a final decision.
And let me ask you this.
Yes.
Today, the court has ended in, another striking note
yes.
To decide on time.
Yes.
Say we have 15 hours to decide, and we're giving party A 2 hours, 15 minutes. We're giving you another 1 hour to respond, and so on, so forth.
Yes, yes.
As of now, that's a source of serious disagreement,
yes.
if you like, and the court has tomorrow decide on this issue among those issues.
Yes.
If you had to give a summary of what happened today,
yes.
why would they say we are in terms of case management?
If you look at the time, let me first of all tell you that if you give me an opportunity to argue as a lawyer whether the mic I'm holding is blue or navy blue or green, we can advance arguments for 2 days. Do you understand? Such that the court must come out clearly and say, look, you will have 1 hour, so and so will have another hour, so that we are able to finish within the 2 days, and then the court has time. So in terms of case management, they had to do that, and there will be arguments. But the court has the final say. They have the final say to say, well, this is the way we are going to do it, and you have to follow, whether you complain, because if they do not decide the petition within this week, then the president-elect will be sworn in, and the decision after that will be unconstitutional. It will be actually null and void. Any decision beyond the constitutional period is null and void. In other words, useless.
All right.
Yes.
I'm Rosweda.
Thank you.
clearly you're amicus mediae, friend of the media. Thank you very much. Speaking there to Ambrose Weda, advocate and LSK council member. That's how case has been treated today. We'll do this obviously tomorrow. To you, Betty.
Well, thank you very much, James Smart, for that detailed overview of what exactly has been happening today at the Supreme Court. And tomorrow, of course, we will demystify